Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. I've decided that lawyers as a group ought to be required to take a class in betting psychology. One of the fundamental tenets of betting psychology is that the reason casinos make so much money is because they operate on variable scale reinforcement, meaning that the slot machines and other games are designed to pay somebody. And obviously, if somebody sitting at the table makes money, well, then it must be that I'm going to make money if I just stay here and keep plowing money into it. And as a result, of course, most people who bet at casinos, irrespective of what they will tell you, lose money. If they have fun doing it, God bless them. I think that's fine. I work too hard for mine to throw it away at a casino. I just think that's really dumb. And I've been to Las Vegas several times. I never throw money at around in the casinos. If I'm going to go enjoy Las Vegas, I'm going to go see a show or do something like that. I am certainly not going to go basically make a donation to the casinos because that's what most people do when they play games of chance. Given all those glitzy lights and all the electricity that is required to power that stuff, their electrical bill's got to be pretty high. They don't pay that electrical bill by paying the winners. They pay that electric bill by fleecing the losers. So again, that's sort of off topic, but it will tie in here in just a moment. Today we're having another one of those lawyers behaving badly cases, and this one is out of South Carolina. There are a number of things you can do in the law and break a rule and not get disbarred. A lot of times you just get a reprimand, or maybe you'll get a 30-day suspension, which is, bad dog, no biscuit, that kind of thing. But if you steal money from a client, if you even convert it for a few days, you're going to lose your license. And you should, because you're violating their trust. And I think all lawyers understand that, but there is almost a pull, I guess, a compulsion sometimes to come really close to that line. And in this particular case, we're going to see that that is pretty much exactly what happened. This is the case of Richard Guy Bush, who was disbarred on November 6th in South Carolina. And he was admitted to practice in 2009. He has no prior disciplinary history. And he owned and operated a title insurance agency called Custodio Settlement Services. And a client hired him to refinance his transaction. He pocketed money and used it to take care of other funds that he had misappropriated from a different real estate closing. And he put this client behind the eight ball with the people who he was refinancing his mortgage with, which was a really awful thing to do to a client. So the client filed a complaint and the bar took action. He admits that he failed to act with reasonable diligence and promptness, and he failed to safeguard money entrusted to him for client A's closing. He misappropriated client A's loan proceeds for his personal or business use, and he was guilty of the violations of dishonesty, fraud, deceit, misrepresentation, and conduct prejudicial to the administration of justice, which is sort of the big catch-all phrase that means basically you caused the public to lose trust in the industry of lawyers, which essentially harms all lawyers. It harms all judges. It harms the courts. And of course, at its very core, it harms the clients. So the second one involved client B. And in client B, it was even more amazing what this guy did. He was an agent for Investors Title Insurance Company, ITIC. So ITIC finds out that he hasn't sent in the documents that they needed in order to consider renewing him. So they suspend him from their active list of agents. In other words, they tell him, look, you can't issue title insurance in our name. You can't do it because we're suspending you. And then later on, his insurance agent license, which had been issued by the South Carolina Department of Insurance, expired. And things just kind of spiraled from that point in time on. He issued a letter on behalf of the client on ITIC letterhead and essentially didn't have their authorization to do that. And then as a result, there was a $172,500 wire transfer that didn't get paid the way it should have been, and the client lost money. The respondent caused a loss to the mortgage company estimated to be in excess of $185,000. As part of a settlement agreement, respondent agreed to pay the sum of $126,000. Now, if you drop down here to the footnote, it says respondent wired funds as an initial payment. He subsequently executed a promissory note for the remaining $93,000 of it in April of 2022. Respondent admits he used funds from client B's closing to replace funds he misappropriated from client A. And that's the way these things happen. You have somebody who steals first from client A, can't pay that back without stealing from client B, steals from client B, and then he's in huge amount of debt and he simply can't go any further. He's toast. Respondent also admits he fraudulently represented himself and his title insurance agency as an authorized agent for the real estate company. And then in Respondent C and in Matter C, he did the same thing basically again. And as a result, numerous companies, numerous clients lost money. And that was not going to sit very well with the South Carolina Supreme Court. Now, unlike California, that doesn't really take that kind of stuff particularly seriously, South Carolina did take it very seriously. And because the disciplinary council worked with this lawyer to try and get to a resolution that didn't involve litigation, he agreed to either a 3-year suspension or a disbarment. Now, if indeed Mr. Bush had, for whatever reason, fought the matter and pushed back and tried to clear his name, which would have been impossible given the facts of the situation, all this stuff leaves a paper trail, and you might be able to categorize conversations differently and say it in a he said, she said kind of situation. But this isn't a he said, she said situation. This is a situation where there are documents, there was a recorded phone call. This guy's goose was cooked. So he came in and did the mea culpa. And the South Carolina State Bar suspended him initially when they found out that he had ripped off one of his clients. And when all the complaints were processed, they recommended disbarment, and the Supreme Court of the state of South Carolina disbarred him. So here's what the court said. Respondent admits his misconduct as set forth above, that it is grounds for discipline. In the agreement, respondent admits the wrongdoing, agrees to a 3-year definite suspension or disbarment, requests that his sanction be imposed retroactively to the date of his interim suspension, and agrees to pay costs. Attached to the agreement is an affidavit in mitigation in which respondent explains that at the time of the misconduct, he was experiencing significant marital and personal stressors, which eventually led him to suffer with depression, abuse of alcohol, and fail to appropriately manage his law firm finances. Respondent explains he is now divorced and has a much healthier personal life. Respondent also expresses remorse for his actions and avers that he has sold various properties to pay full restitution to his clients and others who suffered losses as a result of his misconduct. Based on the respondent's pattern of misconduct, we find disbarment is the appropriate sanction, so they disbarred him. And again, the reason that he got disbarred is because he caused a loss of trust in the South Carolina State Bar. So I believe this is certainly a good case to look at when you're looking at bar discipline and perhaps when you're thinking about what your state bar ought to do. Did you know that in most cases you can find the results of completed investigations against lawyers? Now, if somebody files a complaint, you can't find out if there's a complaint against him. But if he is sanctioned by the bar, you can find that out. And every state maintains basically a website where you can go and look up a lawyer and find out if he's been disciplined by the state bar. And I think, again, that is good because it helps protect consumers from people who do bad things. So if you are really a interested in, or you have a situation where you may need to, at some level file a action against somebody else or have a defense put up for you in an action and you need a lawyer, going and looking at those particular websites to find out whether or not your lawyer has had any discipline is a good thing to do. Now, if somebody was disciplined 15 years ago for something minor, I wouldn't think that would cause me to distrust him. But if he had stolen money, or if he had committed felonies that impacted your view of him as a moral person, then again, I would look at another lawyer as opposed to that particular lawyer. So that's what I have for you today on this case. Thank you so much for being here. If you have any comments, drop them in the comments down below. Any questions, go there too, or you can email me at the address above. Thanks for watching. If you have the opportunity today, do something kind for somebody. And then come on back down here tomorrow. Join me at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point. And although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.